All right, good afternoon, everybody. Yes, today we are back with our second webinar. This one is recorded though, but yes, feel free to also send through your questions at any time, to whatever link we will be posting on this webinar. Today, due to a huge demand of questions that's been raised, we're going to have a chat to Cornel Swanepoel, which is a practicing attorney and also specializing in sectional title. So this is the correct person to assist us with our topic today, the trustees and the liabilities of trustees. I think, when we had the previous webinar that you probably attended or that you probably watched over a recorded version of it, we were discussing, the liability of a trustee, and I was just touching on that point, and hence this is where our first follow-up webinar is taking place because of the overwhelming questions regarding this aspect. And Cornel, welcome to you.
Thank you, Saki. Yes, can I just jump right ahead?
You can jump in.
All right, cool. I think that the role of a trustee in a sectional scheme it's a voluntary one, and it's unpaid position. So it comes with a huge responsibility. And the trustees need to understand that they have a fiduciary duty towards a scheme and its members. And it's important to understand what this means. Now, fiduciary duty refers to a trust relationship between the owners and the trustees. And a duty of trust means that the person will exercise his powers in good faith and will not act in his own interest or for another's gain, but for the people and the owners of the complex. And if we look at the Act, Section 8 of the Sectional Title Schemes Management Act gives clear instructions on how to act in this manner. It refers to a trustee to act honestly and in good faith, exercise his and her powers in the interest of the body corporate, and not to exceed the powers given to him, and at all costs avoid any material interest that they have, and any personal economic benefit that they might receive of a decision that is made. They need to disclose any and all material interest, and it's important to note that should you as a trustee become aware that you have a material interest in any decision taken by the trustees, you have to notify the other trustees and the members of the body corporate immediately. The members of the body corporate must review the facts, and if they agree in writing, they can approve your conduct. But if the conduct is not approved, you can, in your personal capacity, be held liable. And I think that's an important note that we have to, bring to people's attention. If we look at what a material and personal interest is, we usually look at economic benefit. Trustees shall not derive any personal economic benefit to which he's not entitled by reason of his office as trustee of the body corporate, from the body corporate, or from any other person in circumstances which the benefit is obtained in a conflict of interest of the body corporate. And I think it's important for them to understand that this is direct or indirect material interest that applies. And if you look at the personal liability of trustees, any trustee who acts in breach of his fiduciary duties can be held liable in his personal capacity for any loss suffered by the body corporate as a result of the breach, or any economic benefit that the trustee receives as a result of this breach. And I would actually like to refer to some case law in this regard. There was a big case in it started in 2008 and ended up in 2013, the Cape Hall body corporate case. And if I go just in a nutshell, the applicant was an owner and a member of the body corporate, and he claims that the trustees are guilty of gross neglect and incompetence in the management and administration of the body corporate's financial and general affairs. It claims that the trustees are guilty of breaches of their fiduciary duties in respect of the body corporate, and the applicant further claims that as a result of the neglect and the breaches of their fiduciary duties, the owners of the scheme faces continuous prejudice and losses. Now, an application was made to court for placing the body corporate under administration, and the court actually found in favor of the applicant, and the body corporate was placed under administration. And some interesting facts on conflict of interest: the chairman of the body corporate was the sole director of the developer and still owned several units in the residence, and he was also the sole director of a company that performed the functions of the managing agent. Now, the court found that he failed to ensure that his interest in his other companies did not compromise his fiduciary duties to the body corporate, and that he managed the body corporate for his own benefit. The administration was appointed, and after he started investigating, he intended to sue the developer and the trustees in their personal capacity for over 20 million rand. So yeah, it's something that's real. It's something that happens, and we need to be aware. Luckily, there are some relief. If we look at the prescribed management rule 8, it does, however, provide some protection for trustees by stating that body corporates must indemnify a trustee who is not a managing agent at all costs for losses and expenses arising as a result of any act that is not in breach of a trustee's fiduciary obligations to the body corporate. And prescribed management rule 23 further stipulates that a body corporate must take out insurance to cover the risk of loss of the fund belonging to the body corporate or for which it's responsible, sustained as a result of any act of fraud or dishonesty committed by a trustee or a managing agent or employee of the body corporate. So I think, yeah, it's important to note that there is personal liability on regard of the trustees, and you need to protect yourself. And if I can give you the most important thing is knowledge. Trustees need to familiarize themselves with the Act, the Sectional Titles Act, and the scheme's management rules. If you are unsure of anything, of any decision, ask an expert before you act. Also, make sure you appoint a competent managing agent. And I always say a competent board of trustees is the secret to all successful schemes. Make sure you appoint people who are willing to act in the interest of all the members. And again, very importantly, make sure you have sufficient cover to cover for any losses or damages that you might incur as a result of trustees, breaching their fiduciary duties. So yeah, that's just in a nutshell from my side. Yeah, be informed, have knowledge.
Oh, awesome. Yeah, that was quite a mouthful, and thank you very much for sharing that with us. If I can just ask, and this is one of the questions that was posted at our last webinar was, up until what extent will the liability be? And I'm just using as in a layman's terms. I'm a trustee of a body corporate, and because of a decision that we have taken, there is financial loss, as you indicated. Up to what extent am I liable as a trustee? And let's say we are 4 trustees, or all of us liable at the same time. How do they determine that?
Well, it's going to depend on the decision taken. Was it a decision taken by all the trustees? Is there a valid resolution? I mean, you're going to have to look at all the facts. What is the damages that the body corporate incurred? I mean, how involved were you in the decision taken? I mean, there's a lot of factors to consider, but usually the trustees can be jointly and severally liable for the losses incurred if the decision was taken by all the trustees. So yeah, it's going to depend on the facts of each matter, but yes, I mean, if you're not covered and if your decision was taken in breach of your fiduciary duty, then yes, the losses will be shared between the trustees.
Okay, I'm gonna make a statement, and it's probably more than a statement. It's basically also a case. What I want to just mention, and it might help a lot of people watching this recorded version. But in a case of, and I'm coming from the insurance background, where policies being discussed with a managing agent, and that gets obviously taken to the trustees. Up until what extent, because remember now, we as a broker discussing this with a managing agent, and they go and on their own and go and discuss it with a trustee. Is there any liability towards the managing agent that can be moved over from me as a trustee deciding on a fact that a managing agent has mentioned anything to me? Is anything that liability can be moved over from a trustee over to a managing agent?
I'm not sure I follow. If who makes the decision? If the trustees make a decision?
Yeah, I'm just going to reiterate. I want to discuss the insurance policy of the body corporate with the the trustees and the managing agent on his or her behalf said, listen, I will go and discuss it with him, and something goes wrong, where a managing agent was in between this whole discussion. Is the onus still on the trustee to make sure that he's got the necessary information, or can it be handed over to a managing agent in that case?
Well, yeah, if the information wasn't carried over correctly from your side to the managing agent and a decision was made on false information, then the liability can jump to the managing agent.
Okay.
Obviously, then the trustees acted in good faith on the information provided by the managing agent, and then the liability will fall on them. Awesome. So yes, I think it comes down to everybody needs to be involved. Managing agents, trustees, insurance companies, they all need to be on the same page, and the information needs to be come across to all the owners, correctly. Because if not, then there will be liability on somebody's part.
Yeah. And the reason why I'm saying this is that the cases of trustees indemnity, because obviously on your insurance policy you will have cover for trustees indemnity. There's been a huge spike, in claims against trustees. So Cornel, what you're saying is actually 100% correct, because just by us, handling the insurance claims, we can see there's a definite spike, within that. Cornel, how do people get hold of you? If there's any more questions, because I'm sure after this webinar there will be more questions that people might have, or just some clarification on some points that's been mentioned. How do they get hold of you?
Well, they can get hold of me through the My Complex app. I mean, I'm one of the experts there, so they can contact me through that. Or if they want to contact me directly, they're willing to get all my information from your site. I'm sure everything will be available there.
Oh, awesome. It's so nice, and this is what this webinar is all about, is getting the specialists involved. Ladies and gentlemen, for those of you that's been watching this recorded version, I'm sure that this is going to help you. And, at the end of the day, like Cornel just mentioned, somebody is going to have to take a responsibility and liability for whatever decisions and actions been taken. Cornel, from our side, from Besha's side, thank you very much for joining us. Thank you for sharing this information with us. And once again, if anybody's got any questions or any points that they want to make, you can go onto the My Complex website. If you do not have that link, that will be available just after this presentation. Go onto that, go and click on the legal help button and go and post your question. Cornel, once again, thank you for your time, and have a good time.
Thank you very much, Saki, and I appreciate the opportunity to chat to you today. All right, keep well.
Thank you. For any questions on the webinar, please contact www.mycomplex.net. You can just go to the Need Help button and then to Legal Matter and post your question there. Thank you very much for joining us, and have a good day.